Good morning, friends. In this video, I am going to discuss very important case law relating to strikes by our advocate brothers. And the case law is District Bar Association, Dehradun versus Ishwar Sandlia and others 2020. Friends, in this judgment case, Articles 14, 21 and Article 19 were explored. Going into the background of case, advocates in the entire district of Dehradun and several districts of Hardwar and Udham Singh Nagar in the state of Uttarakhand had been boycotting courts on all Saturday. That too for the past 35 years. And the respondent in this case filed a litigation and approached the High Court. The High Court was of the opinion that on all such working days, on account of strikes and conduct of advocates in boycotting courts, it affected functioning of the courts and contributed to ever-mounting pendency of cases. So, Honorable High Court issued directions. So this appeal, present appeal before the Honorable Supreme Court is whether directions issued by the High Court to district bar associations in the state of Dehradun to withdraw their calls for strike and start attending courts on all working days warrant any interference from Supreme Court. So, friends, going to the brief facts in detail, the advocates in the entire district of Dehradun, several districts of Hardwar, Udham Singh Nagar, that are in the state of Uttarakhand, had been boycotting the courts on all Saturday for the most 30 years. Strikes were seriously obstructing the access to justice to the needy litigants. So the respondent, as I already told, was compelled to approach the High Court by way of public interest litigation. Honorable Court noted from the information sent by the Law Commission that with respect to state of Uttarakhand, the work was suffering. So the High Court was of the opinion that on such working days, on account of strikes and conduct of advocates, it had affected the functioning of the courts and contributed to ever-mounting pendency of cases. Therefore, directions had been issued by the High Court. The High Court directed the Bar Associations of Dehradun, Hardwar, and Udham Singh Nagar to withdraw their call and start attending courts on all working Saturday. All the district bar association in the state shall forthwith refrain from abstaining from courts. And also, because of condolence, they should refrain from boycotting courts. And also for some other reason, they should not go on strike. In case they did not start attending courts, the district judges were directed to submit reports to the High Court for its consideration whether action should be initiated against the errant advocates under the Contempt of Courts Act. So they went in appeal, association went in appeal. Honorable Supreme Court dismissed the appeal and held that the court time that this court time and again deprecated the liars to go on strike. Strikes were continued unabated. Even in this case, the advocates have been boycotting the court on all Saturday in the entire district of Dehradun, in several parts of the district of Hardwar and Udham Singh Nagar of the state of Uttarakhand. Because of such strikes, the ultimate sufferer were the litigants. From the data mentioned in the impugned judgment and order, which is under challenge, things are very shocking. Every month, the advocates were on strike and abstaining from working on one pretext or the other. If the lawyers would have worked on those days, it would have been in the larger interest of society and it would have achieved the ultimate goal of speedy justice, which is now recognized as fundamental rights under Article 14 and 21 of the Constitution. It would have helped in early disposal of criminal trials. Therefore, it would have been in the interest of those who are languishing in the jail and waiting for their trial to conclude. When the institutions are facing a serious problem of arrears and delay in disposal of cases, how the institution as a whole could afford such 4-day strike in a month. Now, secondly, it said that so far as the submission of behalf of the petitioner that to go on strike or boycott courts was a fundamental right of freedom of speech and expression under Article 19, Subclause 1A of the Constitution, and it was a mode of peaceful representation to express grievances by large community was concerned, such a right to freedom of speech could not be exercised at the cost of litigants or at the cost of justice or as a justice delivery system as a whole. So, to go on strike, boycott courts could not be justified under the guise of the right to freedom of speech and expression under Article 19(1)(a) of the Constitution. Nobody has the right to go on strike or boycott courts. Even such a right, if any, could not affect the rights of others, and more particularly, the right of speedy justice granted under Article 14 and 21 of the Constitution. In any case, all the said submission by the association has already been considered by this court in earlier decision. So, boycotting court on every Saturday in the entire district of Dehradun and several districts of Hardwar and Udham Singh Nagar in the state of Uttarakhand was not justifiable at all, and as such, it tantamounts to contempt of court, as observed by this court in the earlier decision. So, High Court was absolutely justified in issuing the impugned direction. This court was in complete agreement with the views expressed by the High Court and the ultimate conclusion and the directions issued by the High Court. So, friends, now going to ratio decidendi of this case. To go on strike or boycott courts cannot be justified under the guise of right to freedom of speech and expression under Article 19(1)(a) of the Constitution. That's all. God bless you all. See you again.